practitioner series of webinars organized by LiveLaw. This series is dedicated to promote interaction between students, advocates, academicians, and activists with the senior members of the bar. Our esteemed senior members of the bar have graciously taken out some time to share their knowledge and practical experience in the field of law and to shed light on various topics of great significance. I am Advocate Aditya Sidra and I'll be moderating today's session. In continuation to introduction of law of writs, today's session is Law of Writs Part 2, Writ of Mandamus. We are very fortunate as we are once again joined by Senior Advocate Ms. Vibha Datta Makhija, who will speak on the topic, and then it will be followed by a Q&A session where the audience can ask questions to our guest speaker and she will address the same. You may ask your questions by writing them down in the Q&A tab. Now, I'm delighted to introduce you to Senior Advocate Ms. Vibha Datta Makhija. Ms. Makhija was designated as a Senior Advocate in the year 2013, at a time when during the 62-year-long existence of the Supreme Court of India, only two other women had been designated by it. It was significant since her designation, along with Ms. Meenakshi Arora and Ms. Sushma Suri, broke the glass ceiling for women's designation, after which women are regularly designated standing shoulder to shoulder with men by the full court of Supreme Court of India. Ms. Makhija graduated in History Honours from Lady Shri Ram College, University of Delhi, and alumna of Campus Law Center, University of Delhi. She went on to pursue her LLM from the prestigious Georgetown University of Law, Washington, D.C., USA. Ms. Makhija was associated with late Shri Arun Jaitley ji, senior advocate and former Union Minister of Law and Finance from the year 1992 when she joined the bar till the year 2000. She is a member of Asian Law Alumni Advisory Board, Georgetown Law University, Washington, D.C., and acts as an advisor to the board, advocating the interests of Indian students at the university. She is presently the chairperson of National Anti-Doping Appeal Panel. Ms. Makhija is an active member of the Supreme Court Bar with an extensive practice in constitutional law, criminal law, service law, corporate law, and insolvency and bankruptcy proceedings. Ms. Makhija has authored the Halsbury's Laws of India on negotiable instruments and regularly makes written contributions to the Bloomberg Quint, the Tribune, LiveLaw, and other journals on various legal issues. Ma'am, we welcome you and we are truly honored to have you on the panel once again. The topic of today's webinar is Law of Writs Part 2, Writ of Mandamus. Ma'am, I invite you to please elucidate upon the same.
Good evening, everyone. So we've had one earlier session on the writ jurisdiction, and in the last session, I had basically covered the historical perspective to the mandamus and the writs as found in our constitution. So just kind of retreading back on that path for those who were not with us on the last occasion. Essentially, the issue that arises in most democracies is how to guard the guardians. So by a theory of social contract, we have given the authority to our governments to govern us and to exert their authority. But the question remains as to who will control the authorities if they act beyond the purview of law. So this is a situation which existed for as long as probably authority has been exerted. And it then developed into, what should I say, well-recognized doctrine in English common law, whereby king's writs would be issued to control persons who were put in authority. So the persons in authority of the executive were subject to king writs. And the king's writs basically mandated these authorities to exert their authority in accordance with law, what was prescribed by law in accordance with principles of fairness and justice. And thus, because these were not remedies which were ordinary, in as much as they were not a part of a statute or a regulation, these were known as prerogative writs and as such extraordinary writs. And there were several kinds of writs that issued. And in fact, traditionally in England, these were plated. So it was like a format which was printed and the blanks were filled in by hand. So there were types of writs which developed. And the common amongst them, of course, are habeas corpus, certiorari, mandamus, quo warranto. So these are the forms of writs which we recognize under our constitutional regime. And as such, as time went on, various, various countries, when they developed their judicial systems, they incorporated the system of writs either by statute or by constitution. Since we historically derive our judicial system from the common law, as far as UK is concerned, writs formed a part of their common law corpus for the longest time. And it was only very late, I think in the 1990s, that they were formally included by way of a statute in their civil procedure. So as such, various writs which are issued by the English courts, so to speak, have a statutory standing as of now. Similarly, in the American scenario, as far as writs were concerned, they did not form a part of their constitution. The Constitution recognized only the writ of habeas corpus. It was only in 1911 that by way of a statute, they introduced the Writs Act, by which the federal courts were authorized to issue writs to face various issues and grant various reliefs. It was our Constitution in 1951 when our Constitution came by way of Article 32 and Article 226. Writs were recognized as so important to the entire scheme of justice that they were incorporated in the Constitution itself. And by way of Article 32 and Article 226, the scope of powers which were given to the courts were so expansive and so strong that I think the expanse of writs in the Indian jurisdiction is one of the most vibrant expanses. And we get to see this from time to time by the manner in which the Indian courts exercise their writ jurisdiction. In fact, there always are comparisons between the Indian constitutional law, the UK, and the US. And I have been told that justices of the US Supreme Court themselves wonder at the power under Article 32 and Article 226, which their constitution does not provide. According to Justice Kalia, who is an originalist, he says that our constitution, that is the American Constitution, does not give us the power to exercise the remedy which is incorporated in Article 32, the way it is there in the Indian judicial system. He feels that the American system does not allow so much space for judicial activism, does not give so much power to the courts to exercise their judicial power as the Indian Constitution gives. And it is actually an issue of wonderment for other jurisdictions to examine the scope of writ jurisdiction. As such, the writ jurisdiction is exercised to remedy wrongs which are inherent in most human values. And constitutionally speaking, they are utilized to enforce fundamental rights. Article 32 is the article which prescribes the remedy to enforce the fundamental right. So even though the government, even though the citizens would have fundamental rights, until and unless they had a right to enforce those fundamental rights against the executive or public bodies, the scope of those rights would not be fulfilled, in as much as they would be, I would say that they would almost be like directive principles of government policy, where the government is given a duty to perform its functions in a particular way, but they are not enforceable functions. So it is with the strength of the writ jurisdiction that the functions which are allotted to the government and the rights which are given to the citizens are enforced in the judicial forum. Now, Article 32 is the article which gives the citizen the power to approach the Supreme Court for enforcing any of his fundamental rights. As such, what happens is that only if your fundamental rights are infringed, and this would exclude all other rights, which would be probably other legal rights, statutory rights, rights at common law, the jurisdiction automatically does not originate in the Supreme Court. Article 226, however, is very expansive in its scope. Article 226 mandates that any citizen who wants to enforce either his fundamental rights or any legal rights can approach the courts, and the high courts are under a constitutional duty to enforce those rights in favor of the citizen, provided that that duty, which has to be discharged by an authority, is a public duty. Now, there are several kinds of writs, and why we say that there are several kinds of writs is because there are several kinds of orders that courts pass. So it is the nature of the order that will be passed which determines which writ is to be invoked. Therefore, this writ of mandamus is a writ by which the court directs a public authority to perform its public function, which would include its legal duty, in the manner that is provided in the law by way of constitution, by way of statutes, by way of customary laws, anywhere where a legal right arises in favor of a citizen. The executive is required to perform its function in accordance with the right and the method in which they are required to exercise their functions. Whenever an authority does not perform its functions in accordance with law, the courts are empowered to direct them and issue a mandamus to them, directing them to perform a function in a particular way or to refrain from performing a function in a particular way. Therefore, it includes both acts of commission and omission. And in case an authority is not performing its function, for example, if it is required to grant you a license and it sits over your application and does not give you a license, you can invoke the jurisdiction, move the High Court for a writ, and you can ask for the relief of mandamus to enforce that right of being able to be granted a license in accordance to the eligibility conditions which are prescribed. So in cases where the authorities do not perform their functions, which they are required to perform, or in cases where they are performing their function contrary to the authority that is given to them by law, is when you invoke the writ of mandamus. Now, usually there is a lot of confusion between the writ of mandamus and the writ of certiorari. Now, writ of certiorari, so to speak, an easy way of understanding a writ of certiorari is to remember that certiorari means quashing. It is to certify. Certiorari, so to speak, literally translated, means to certify. So if the court certifies that it quashes an order, then it puts its stamp on declaring an order as a nullity. So therefore, what happens is that whenever a litigant is aggrieved by the action of the government or lower tribunals, it always have a grievance which can be raised in various ways. So to speak, if an order is issued by an executive authority, taking the example of the licensing authority, suppose the licensing authority issues an order rejecting your application for license. So you will move the court asking for a writ of certiorari to ask the licensing authority to grant you a license. And secondly, you will also ask for a writ of mandamus directing the licensing authority to perform its actions according to the scheme which is given in the law. So the licensing authority will be bound by the manner in which the license has to be granted in the statute. So for example, under the municipal law, a license for hawking has to be given. So in that scheme, the municipal commissioner will probably work out a scheme and will work out certain eligibility criteria. So if you fit into the eligibility criteria and still your application is rejected, you will come to court asking for two reliefs. One would be the quashing of the rejection order, and secondly will be asking for a direction that your license may be granted by the authority acting in a particular manner. So therefore, the most common thing that most of you must have heard when court proceedings go on is when the judges say that you reapply to the authority to consider your application. So when this order comes from the court, which says that the authority shall consider the application or the representation of the litigant, it is actually a mandamus which is issued to the authority. So the simple way of remembering and distinguishing a mandamus from a certiorari is to remember that mandamus is a direction and certiorari is quashing. That is the absolute thumb rule and easy manner of remembering of how to distinguish between the two writs. Now, in these cases, what happens is, in fact, I'll relate to you something that happened to me when I joined the legal profession. When I joined the first chambers that I did as an intern, not as an associate, I was given a brief to read. And so I asked my senior, what is this brief related to? Is it law of contracts? Is it law of torts? Is it law of evidence, CPC? So I was told that a brief will involve several issues, and it's not like a course, law course, where you will have a particular paper which will be relatable only to a particular field. It will have various aspects. So therefore, what happens is that there are some writs which we call as certiorari writs. So these are certiorari mandamus where both the things issue, a certiorari quashing the order and a mandamus to pass an order in a particular way. So both the issues get covered in situations like these. Now, another issue that arises is that why is there so much significance and importance of writ jurisdiction. So the significance and the importance of writ jurisdiction arises because of what one would call is the basic feature of any judicial system, and which is to ensure that there is no transgression of law and transgression of law by authority. By way of various statutes, the legislature provides for various remedies in various spheres. So, for example, in law of contracts, your remedies lie under the contract law. For example, in consumer disputes, your remedy lies under the Consumer Disputes Forum. For example, if there is any issue with regard to, say, insolvency, you will go to NCLT and NCLAT. So there are special mechanisms, tribunals, which have been created to address special spheres of relationships. What we call these are relationships. And essentially, relationships occur in the field of public law and in the field of private law. And the writ jurisdiction is invocable only in the sphere of public law. So what is the sphere of public law? The sphere of public law is the sphere where any authority, which is an authority, government authority as defined under the Constitution, when the authority has a legal duty to act in a particular manner. So that is the area in which the public law remedy lies. Private law remedies are typically remedies which will lie in civil courts, for example, as a civil suit, a summary suit, or say a remedy under the Negotiable Instruments Act. So those are private contracts, private relationships, which are covered by private laws. Now, when we deal with public laws, there is, I would say, every day it develops. Courts think, rethink, look at the manner in which an authority exercises its authority, looks at the result and the significance that the authority has in public life. So let me take an example, for example, that of the 2G scam. Going by what happened in the 2G licensing area, 2G licenses were, tenders were issued for licenses to be issued. Advertisements were there, issued by the Ministry of Telecom, in which certain criteria was given, which was a first come, first served criteria. A lot of persons who would be eligible to apply for these licenses, a large number of telecom companies, smelt a rat over there and said that this policy of granting license on first come, first served basis is a flawed policy because it excludes a large number of people only on basis of the timing of submitting your application. So as such, it is not a criteria which has a nexus to why the license is to be granted, which is to ensure uninterrupted telecom services in the entire country. So they moved TDSAT, which was the specialized tribunal to look after telecom matters. It had a special jurisdiction. TDSAT rejected those petitions, saying that this is government's policy and we will not interfere. And we don't see anything wrong in government setting up a policy on basis of which no malafide is alleged and there is no foul play. So TDSAT refused to interfere. Then the Cellular Operators Union Association went to the Delhi High Court, invoking the writ jurisdiction, saying that the Telecom Ministry has a public duty. So although eventually it's going to be a contractual duty, which is that a matter of contract between the government and the licensee. However, this involves public funds, it involves public largesse, and therefore, if the policy is against Article 14, if it is arbitrary or discriminatory in any manner, or if it violates any other provision of the Constitution, then this policy must be struck down. And a more equitable policy should be floated by the ministry to give equal opportunity to everyone to be able to apply on basis of merit rather than on basis of who rushes to the ministry first. Again, the High Court refused to interfere. High Court said, hands off, matter of policy, matter of contract, we will not exercise our writ jurisdiction. Finally, a writ petition was filed in the Supreme Court. And that is where the Supreme Court decided to interfere. So what is it that made that tipping difference, that Supreme Court decided to interfere, whereas the High Court held its hands off? What the Supreme Court came to hold, that whenever there is a public duty, even if it may be in the sphere of contractual area, the courts have a duty to interfere. The writ courts have been enjoined by the Constitution to exercise their writ jurisdiction, to set it right anything for which there is no other public remedy. And if there is a problem and the courts are able to come to a reasonable satisfaction that the public authority has not performed its functions, not only in accordance with the procedure which is prescribed by the law, but also with the principles of fairness and justice and equality. And that is when the Supreme Court struck down this policy. It also issued various other directions. And that's where they exercised their writ jurisdiction. Several directions were issued, which were in the form of writs of mandamus. So what we see over here is something that is constantly evolving. Many times the courts refuse to exercise their jurisdiction, say that in their discretion, they feel that this is not a case which is grave enough to exercise their writ jurisdiction. So the areas, let me just go back a little. One core element, which is that the exercise of writ jurisdiction is a discretionary power. So the courts have an inherent and discretionary power to exercise their jurisdiction, and there is no mathematical formula by which the law prescribes that if condition A, B, C, D subsists, the court must issue a direction. Unlike in statutes, where it is prescribed that if these ingredients exist, then the court will exercise its jurisdiction and grant compensation. For example, in motor accidents acts, compensation cases, etc. So the writ jurisdiction being a discretionary jurisdiction, the courts exercise it very sparingly. They exercise it looking at the nature of the public duty which the authority was bound with, and the infraction of the legal right of the citizen, whoever is complaining of that infraction. And thus, there are some self-imposed restraints that the authorities have, that the courts have put on themselves. The first and foremost of these restraints is that of an alternate remedy. So whenever there is an efficacious alternate remedy, the writ courts usually do not exercise their power of mandamus. So for example, if there is in a statute a 2-tiered or a 3-tiered redressal system, then the high courts will refrain from exercising their writs of mandamus. So let us take a hypothetical case of a employer-employee relationship. So suppose X is an employee of a PSU, say Indian Oil Corporation, and he has been accused of some kind of a misconduct. So his service rules will provide the methodology by which the charge sheet has to be issued, how he will make a response to it. Then he will go to the disciplinary authority. Disciplinary authority will pass an order. Disciplinary authority will pass an order of punishment. Then he will go to the appellate authority, which is again provided in his service rules. So when he will go to the appellate authority, so suppose the disciplinary authority at this point of time says that we terminate your services, we fire you, and you are now guilty of misconduct. So this litigant will not be able to come to the High Court directly and challenge it, because he has an extremely efficacious and alternate remedy, which is the appellate authority, which is provided in the service rules. However, if there is a case where there has been an error of jurisdiction, that going to the root of the exercise of power by a particular authority, he can come to the writ court and invoke the writ jurisdiction and say that this authority is not authorized to take action against me. So suppose there is a particular authority which is provided in the IOC rules. Instead of the chairman of IOC, for example, Minister of Petroleum and Natural Gas issues him a show cause notice, that will be quashable because the authority which has been provided in his rules is that of the chairman of IOC. So therefore, because there is an apparent error of jurisdiction, he can come to the court and ask for a writ of certiorari to quash the minister's order. He can also ask for a mandamus, saying that direct the minister not to issue such orders against me. So in this situation, since there is an efficacious remedy, and the alternate remedy has to be something which has to be efficacious. Many a times what happens is that there is an alternate remedy, but that remedy is a long and winded methodology of invoking your remedy and getting the relief from that remedy. At that point of time, in that situation, that remedy is not efficacious. As such, the writ court will again interfere and say that this alternate remedy is actually not efficacious, will not give him a remedy which will be quick and which will be commensurate with his complaint. Therefore, we exercise our writ jurisdiction and we grant him the relief that he is seeking. So, a case in 1952 issued in case of Govardhan Das Bhanji. This is a very famous case, and Justice Vivian Bose authored this judgment. So at that point of time, Mumbai was just being developed and cinema licenses were being given. The commissioner of the municipality had an advisory committee, and he issued, I think he issued an order saying that he should be granted a license to set up a cinema. However, there was an interference by the minister, and thereafter it was revoked. The license of setting up the cinema was revoked, and thus he challenged the revocation of the permission which was given to him to set up the cinema hall. While going through this entire complaint of the litigant, what Justice Bose observed was this, that the remedy has to be clear, efficacious, and it has to be wherever there is an infraction, no matter what, there has to be an authority which exercises its jurisdiction. Therefore, coming to the court and asking for a remedy under the writ jurisdiction, it was maintainable, and the complaint which was made by the petitioner was a valid complaint, because the authority under the law was required to issue a license if certain eligibility was met. However, it did not have the authority to revoke it if those eligibility criteria continued in his favor. So the illegal revocation could be addressed by the courts. So one of the arguments which were raised by the government was that at this point of time, the old Specific Relief Act was in vogue, which was 1877, not the new one, saying that he has a remedy under the Specific Relief Act, that if there is a infraction of any duty of the government and a promise has been broken, because a contractual promise was broken once he was given the license, then there was a contract between the two parties. So if this promise is broken, then his relief lies in the Specific Relief Act. So what Justice Bose said was that the issue was not breaking of the promise. The issue was the acting of a public authority where it owed a public duty to its citizen to act in a particular manner, and it had failed to do so. And thus, the remedy under Specific Relief Act was not an efficacious and alternate remedy, and a writ of mandamus very much lay with the court to direct the authority to act in a particular manner. So in this manner, the jurisprudence in India developed, and the courts have time and again, high courts as well as the Supreme Court, and in fact, on a lighter side, the lawyers who used to practice when we had just joined the bar used to complain that the writ jurisdiction is soon taking over the original jurisdiction. And especially since I practiced at the Delhi High Court to start with, which has an original jurisdiction in the High Court. Mostly High Courts don't have the original side jurisdiction. The well-seasoned lawyers on the original side would always joke with many of us who practiced a lot more on the writ side that your practice is far easier. You are not bound by rules of evidence. Most of your matters are decided on affidavits. And this jurisdiction is soon eating up most of the laws which are there in terms of, suits and specific performance of contracts, etc. So, but the thing that I think we should realize is this this direction of the courts is very much in keeping with our constitutional values, and also it also subserves the primary objective of justice, because the writ jurisdiction, being a strong and an expansive jurisdiction, is a powerful jurisdiction which empowers the citizen finally. The citizen is not running pillar to post. He is not mired with long delays, waiting for his suits to be decided over decades and decades. So in a manner, so to speak, in my opinion, writ jurisdiction, and especially the writ of mandamus, empowers the citizen a lot. So here I will also like to mention how it has empowered the American judicial system. Now, in the American Constitution, only the writ of habeas corpus is mentioned. And very early on, when the whole issue arose about separation of powers and the primacy of legislature versus primacy of judiciary in the separation of powers, in the most landmark judgment of the US Supreme Court, which is Marbury versus Madison, it was settled that since it is the judiciary and the Supreme Court, which decides whether a law is valid or not, its interpretation of the law will have primacy over the legislature's prerogative of declaring a law. So thus, any law that is made has to fall in line with the constitutional values. And this is exactly what our basic structure doctrine is, that the courts, the power of judicial review is a part of our basic structure. And it being a part of the basic structure, this power cannot be taken away by the amending power of the Constitution. So any statute or any provision which whittles down the power of judicial review of courts, and especially of the writ courts, is contrary to our basic structure, therefore contrary to the Constitution, and will definitely be struck down by most of our courts, whether it is any High Court or the Supreme Court. So, in fact, I was talking to Aditya and the organizers, and I was thinking that maybe I will field more questions, because in the theory part, there are, it is a very short kind of a theory, but the issue is how it is applied case to case, and where it will be, the discretion will be exercised or not be exercised. Another important aspect, and where I feel some kind of conflict comes in, is judicial activism. So many a times what happens is that PILs are filed, or maybe not even a PIL, a personal litigant may be aggrieved by a particular action of the government. In that jurisdiction, there are a lot of times vacuum in law. So the legislature may not have clearly exercised its power and made law in a particular sphere. And the most outstanding case in this field is that of Vishaka. So with regard to sexual harassment at workplace, though we have treaty obligations, the Indian Parliament or the state legislatures had not come up with any enactment which would govern sexual harassment at workplace. The redressal of victims of sexual harassment had to take either the normal criminal course or file civil suits against persons against whom they were aggrieved. In that situation, in that particular case, the Supreme Court held very clearly, and Justice Verma, if I'm not mistaken, Justice Verma authored the judgment. And he said that wherever there is a legislative vacuum in the doctrine of separation of powers, we are not taking over their power. What we are doing is we are just temporarily filling up the vacuum by issuing guidelines, so that when there is no law in that area, our guidelines will act as law during that period till such time the legislature legislates on a law. So normally the courts will hold back from passing a mandamus and directing the legislature that you please enact this particular law. So the court, what the court would normally do, the constitutional court, is to say that there is no law in this sphere. And because there is no such law, we issue these guidelines. And in case the legislature passes law in that area, then the law which is passed by the legislature will operate in precedence over our guidelines. So the Supreme Court, so to speak, has very nicely maintained its duty to maintain separation of powers, has seen that there are certain areas which need to be addressed. And a lot of times it's because the governments abdicate from performing their legal duties. It was the duty of the government to make a law expeditiously on sexual harassment of women at workplace. I mean, I think in gender equality, that would have been one of the foremost laws for the government to make. However, since it wasn't there and there was a dire need for it to exist, the Supreme Court said that we issue these guidelines. And as such, it was not a mandamus, but it was guidelines which were to be issued by Supreme Court, which were to operate as law, because the judgments of Supreme Court are binding. And till such time that the legislature came up with a legislation. Similarly was the case of Islamic Academy. This was the case with regard to schemes to ensure that there is no capitation fee, that there are no admissions in private institutions or government institutions which are contrary to merit. And so the Islamic Academy also issued guidelines saying that you set up committees. There it issued a mandamus saying that all state governments will set up committees to oversee the admissions to all the professional colleges until such time that the states enact laws. Then these committees will perform the function of overseeing fair and just admissions into professional colleges till such time that the legislation came along. And so to speak, some governments, some states came up with the legislation, some did not. But a kind of a uniform setup parameter was given by the Supreme Court, which is now uniformly applied in all states with regard to professional admissions in colleges. So that is one area where the legislature and the government have a problem with over-expansive action of the judiciary. However, the said action is in line with the Constitution, in line with the powers which are given to courts, and especially to the writ courts, which are the constitutional courts, which have been empowered by the Constitution, not in contradistinction to statutes. And statutory power would be at a lower level than the constitutional power. So, by and large, I would say that this is a general overview of the writ of mandamus. If I think I'll take some questions. Adi, are there enough questions?
Ma'am, we do have enough questions for you. So,
okay. So, because I think it's important for people to ask me their doubts rather than me to speak more about this.
Ma'am, we have very interesting question. This is, there are certain fundamental rights which are provided to foreigners as well. So if those rights get violated of a foreigner or of a non-citizen, can such a foreigner also move under the writ jurisdiction of the Supreme Court or the High Court for making good those rights?
Yes. So basically, for example, the right to personal liberty under Article 21 is available to every person. It is not limited to citizens. And the Constitution makes a distinction between citizens and persons. So if a person's, even if he may be, for example, we have a lot of cases where there are people, foreigners, who are caught, who are drug carriers, for example. So you must have heard of the cases of a couple of Nigerians who were caught, and there are several cases. So they can approach our courts and file writs of habeas corpus and enforce those rights, because certain rights are available even to foreigners under our Constitution, and personal liberty being the most important right.
Ma'am, another question. So When grievance has not been raised with the public authority, can a person without raising such a grievance with the public authority itself move to the High Court or the Supreme Court for a writ of mandamus?
Okay, so now what happens here is that, again, let's go back to the basics, which is that this power which is exercised is discretionary power and it is extraordinary power. So what happens here is that this power has to be exercised to ensure that the authority is performing its legal duty in the manner that it is required to perform it. So, for the court to be satisfied that the authority has not performed its duty as per the mandate of law or principles of fairness and justice, it will ask the litigant whether it had approached the authority who was under a duty to perform that duty. The litigant has to satisfy the court that there is a failure of performance of duty. And in a case where the authority itself has not been approached, if the invocation itself has not been done, then the courts will not interfere. So, therefore, the courts always desire that you should have approached the concerned authority before coming to the courts. And as such, the courts normally say that your writ petition is premature. You go make a representation to the authority. Let the authority apply its mind. In case it doesn't apply its mind according to what the law asks it to do, then you come to us. So by and large, going to the authority to air your grievance is a step which you must take before coming to the courts.
So, ma'am, there was one very long question. I'll try to sum it up and ask it in a short manner. The question is, can a person move directly to the High Court if the trial court is not following proper procedure or is withholding records and is not allowing the plaintiff to participate in the proceedings properly? So, can such a issue be raised in a writ of mandamus before a High Court?
No, the more appropriate remedy here would be to invoke Article 227, which is the power of superintendence of high courts over subordinate courts. So, as such, what is happening here is that the subordinate court is not performing its duty, which it is required to perform in a particular fashion. If it goes against procedure, against CPC, for example, if it is a civil suit, then there'll be certain provisions of CPC that it may be violating. In such a situation, if there is a misconduct or if there is a complaint against the judge, then the more appropriate jurisdiction is the superintendent's jurisdiction under Article 227.
Also, ma'am, so we see a
However, in case the judge has no jurisdiction over the matter, for example, he takes cognizance of a matter in which he doesn't have, say, the territorial jurisdiction or, say, the pecuniary jurisdiction, then a writ of quashing will lie. Then, because it becomes a jurisdictional issue.
So prohibition if the matter is still not decided, and certiorari if we decide.
Yeah.
Also, ma'am, a number of times we see that in tender matters, a lot of bidders, when their bid is not considered for one reason or the other, they tend to move into writ jurisdiction, especially under mandamus, to get their bids considered by the government. Whereas, should such matters actually be taken up in because these are under the writ jurisdiction, being contractual disputes in themselves?
So this is a very interesting aspect of writ of mandamus, and the courts have seen a very turbulent this thing in it. So essentially, the basic criteria for courts to not exercise their discretion is if the matter lies in a purely contractual area. However, what happened was, say in late 1970s and early 80s, a large number of public projects were undertaken by the government. And although the government acted in its commercial and in its contractual duty, however, it was distributing the public largesse, because when you build up a project, it is the public money, it is the public resource which is being distributed to various people for a particular purpose and consideration. So the courts expanded and in fact distinguished and said that if it is purely contractual in a private area where it is a private party versus a private party, and there is a methodology of resolving that dispute, then we will not interfere. However, when it comes to a public duty, so therefore grant of tenders, contracts, public employment, ports, airports, all these came under the distribution of public largesse, and therefore even in its contractual capacity, the state had to perform in accordance with the constitutional provisions, including Article 14, and could not behave like a private contractor and had to take the mantle of a state contractor, which has certain additional duties which are put on it under the Constitution. So, the one significant case here was that of LIC versus escorts. What happened here was that there was some FERA scheme by which investments could be made in Indian companies by NRIs on basis of some criteria. So Swaraj Paul's family started investing in escorts, and LIC was a majority shareholder of escorts. So it held, I think, more than 50% shares in escorts. And because you hold so many shares in a particular company, what also happens is that you get to appoint your directors and so on. So because escorts wanted that money and wanted to transfer the shares, and LIC on the other hand said that there were some violations of RBI guidelines and FERA, etc. So it did not want to transfer the escort shares in favor of Swaraj Paul and his family. So they moved a resolution in the board meeting proposing to remove a large number of directors, I think. And there, escorts moved a writ petition in the High Court saying that LIC should be injuncted from moving this resolution, and we should not be required to be voting on this. So the High Court granted them relief. But what the Supreme Court said was that this is in a completely Companies Act domain. These are governed fully by the Companies Act. These are not public funds. These are private companies, private people who are fighting against each other. And LIC is not acting in the capacity of a state contract with regard to public largesse. So in this sphere, writ jurisdiction will not lie, and a mandamus should not lie that that LIC should be injuncted from moving its resolutions, proposed resolutions. So the court withheld. So the Supreme Court said that the High Court should not have granted the relief that it did to escorts. There, Supreme Court refused to interfere. But there are a large number of cases of contracts. For example, R.D. Shetty versus the Airports Authority. Then there is ABL International Limited, where the courts have said that wherever it is a public money, public largesse that is being distributed by virtue of contracts, there the courts will step in if they see that there is arbitrariness, discrimination, and violation of Article 14. So in those areas, the courts always steps in. And even if there are a few disputed facts, if they can be resolved on affidavits, the courts normally interfere in those cases if they see infraction of Article 14 principles.
Ma'am, related to this question only, can a company move a writ petition under mandamus only in High Court and not in the Supreme Court? Because fundamental rights cannot be assigned to a company.
See, it also depends. Company is a corporate entity. It has been held that a corporation has a separate entity of its own. So therefore, if there is an infraction of fundamental rights of a company, it can move the Supreme Court for sure. For example, Bennett and Coleman. So when there was the issue of and Indian Express, which was the cases of newspapers of free speech, and the companies moved the court in jurisdiction. So if there is an infraction of fundamental rights of a company, which also has a right to freedom of speech, then it can definitely move the court.
Ma'am, another question. Can you explain the continuing mandamus, especially in terms of PILs, wherein the courts have actually passed orders in terms of continuing mandamus?
So this was in case of, I think one can say that the case which illustrates this position is, I think, Justice Lokur's judgment in the Section 6A of Special Police Establishment Act, where Section 6A of the Special Police Establishment Act was challenged. So if a cause of action keeps on continuing, so one of the grounds on which the courts refuse to exercise discretion is delay and laches. But if you're aggrieved by the very provision, then there is a continuing cause of action for you to invoke the writ of mandamus, and that can be done.
Ma'am, another question. Can a writ petition be filed in High Court to challenge the constitutional validity of an act passed by the central government?
In the High Court, of course. Definitely. Why not?
But this would not fall within the writ of mandamus.
You see, when you are asking for a declaration, that is different from asking for a direction. So when you challenge an enactment, you are asking for a declaration for declaring a law as ultra vires the Constitution. So that is a very different domain from a mandamus, but a mandamus may flow out of it. So if the law is declared as ultra vires, then the mandamus flows out of it, giving further direction. It's like consequential relief, that because the law has been held to be ultra vires, therefore mandamus be issued for the government to function in this particular fashion, the authority to perform its function, not in accordance with the provision that has been quashed, but in a different manner.
Ma'am, one more question. What are the essential ingredients of... Sorry?
Let me explain this a little better.
Yes, ma'am.
Because it's a good question, and it's something which needs a little more clarity. So it's like when you challenge an action of an authority, there are several grounds on which you will challenge that action. You will say it is bad because it was malified action. It was bad because it was violative of Article 14, because it was discriminatory. It discriminated me against the person sitting next to me. It was bad because it was arbitrary and thus thus violated Article 14. Then you also will say that it is bad because this provision itself is bad. So then you ask for a declaration of declaring that provision as bad and the consequent action taken under that provision to be quashed and mandamus to be issued to take action in a particular manner or not take in a particular manner. So for example, if the authority has taken into consideration certain extraneous considerations while coming to a decision, then the mandamus will come saying that you will not take A, B, C, D considerations into account while coming to a decision. So that will be your mandamus. So it's a play of a large number of things together.
I remember similar to the case in which you had argued where the municipal corporation under the bylaws had introduced a new formulation for calculation of the tax, and therein the validity of the whole bylaws was challenged, and then a writ of mandamus was in accordance in action not to be taken and the tax not to be calculated.
Rateable value formula of the NDMC, I think you're talking about.
Yes, ma'am. Yes, ma'am.
Market matter.
Right, ma'am.
Yeah.
Ma'am, another question: if a lower court, be it a trial court or a high court, reserves a judgment and does not deliver the judgment for more than a year and a half, can can a writ of mandamus be moved against such an action or inaction?
So here again, I would advise to go under 227.
But it can be approached under
But
227.
yeah, because I mean, jokes apart, but you see, speedy remedy is also a part of our fundamental right. So if it is violating my right to speedy remedy, speedy and effective remedy, a writ jurisdiction can certainly be invoked.
Ma'am, one final question. So this has been asked by Nitin Mehta, saying, what are the essential ingredients for writ of mandamus, and can a decision of the High Court exercising writ jurisdiction be challenged?
He was not paying attention in the beginning of the lecture.
Looks like. Uh,
So those were enumerated right in the beginning. So it is a writ, meaning an order issued by the courts, a judicial authority against an executive or an inferior judicial authority to issue a direction to act or not to act in a particular manner, which has to be in accordance with the legal duty borne by the authority whose action is challenged.
one last question. Another one by Rakesh Behra. Can a writ lie in High Court against a statutory body for committing an act of private nuisance which has resulted in interference with right to legitimate use of land? So can a writ be filed against a statutory body for causing private nuisance?
See, as a lawyer, I'm not going to give a theoretical answer here. I'm going to give an answer as a lawyer here. So, as a lawyer, the moment your opponent is a government or a government authority, think in terms of a writ. And certainly, if you can bring in the action, which is a public action, a public duty. So, a statutory authority, besides having the various duties that it has under the statute, also has a duty to follow the constitution. So if the nuisance is of a nature which impairs, say, your right to sleep, which is a fundamental right under the constitution now in Baba Ramdev's case, so you can definitely invoke the authority. Or for example, the statutory authority is blaring loudspeakers after 11 p.m. Again, it is a right to health, which is a fundamental right. So any statutory authority which may violate any of your fundamental or legal rights, and because the High Court has a more expansive jurisdiction, which includes legal rights, which includes your rights under common law, the jurisdiction can be invoked, but I will advise you to word it a little creatively. That's what I would say.
Thank you so much, ma'am, for giving us such an in-depth analysis of the writ of mandamus. Now, I'll finally conclude by saying thank you to all the participants as well for sending us such lovely questions, for making this session so interactive. Ma'am, we really hope to see more of you, and we hope you educate us further on more writs and maybe other topics as well. So hopefully you can join us more on this platform and educate us further. And finally, I'll close the session by thanking everyone for joining in. And we guys hope to see all of you again. And